Hi, what's your name, please?
Jasmine Payne.
All right, Ms. Payne. Calling case number 240-559-5801, people of the state of Michigan versus Jasmine Payne, counsel.
Thanks again, Judge Steve Benson for the people.
Jessica Sharp on behalf of Ms. Payne, who is formal reading, understands her constitutional rights and stands mute.
Thank you, counsel. The court notes formal reading has been waived in interest of not guilty plea on your client's behalf. I'll hear arguments as to bond.
Judge, a little out of the ordinary for how it's being charged. We're going to be asking for $75,000 cash. We're also going to be asking for tether and house arrest. The defendant does have two pending matters in 3060. She was actually just arraigned on those, I believe, a couple of days ago. One having to do with an MDOP. One's an ongoing MDOP that's a felony. Another one is a misdemeanor. Now, ironically, Judge, in the misdemeanor case, there was a condition in that of no contact with the complainant or the address. That same complainant and address is the individual and the location of where this alleged incident took place, Judge. There were also failures to appear in both of those cases. She was arraigned on bench warrants, but I'm not going to hold that against the defendant right now, and I'll explain the reason why. So in addition to the two cases that she has ongoing over in 36D, one, she's on probation from Macomb for domestic violence. She ended up getting a conviction in February of 23. She got jail time as well as 24 months. And then, Judge, in May of 2023, she ended up spending additional time in jail because she got convicted of an OWI. And then in December of 2023, Judge, she just ended up getting convicted for a misdemeanor police officer R&O. Now, Judge, I think because she had to spend some time in jail on that, I think that may actually explain off some of the capiases over in the 36D, which is probably the reason why the cash bond was converted to a personal bond. But in addition to all of that, Judge, while either, and I couldn't nail this one down, while either she was in jail for the OWI or the DV in 2023, she somehow successfully assaulted a prison employee and she ended up pleading to that. And that plea came in December of 23, and that was actually deferred under HIDE. So we have the DV where she's on probation for, and then the subsequent convictions, and then the assault on a jail employee. We have the two ongoing cases in 36D. And oh yeah, let's get to the allegations in this case, where not only was there a no contact, there's a PPO against her by the complainant. And she takes her car, goes over to that residence, rams her car into the complainant's car, and then tries to run him over. And there are tracks on the sidewalk that actually show what the defendant attempted to do, corroborating the complainant's story. He fortunately wasn't hit. He was able to get out of the way before she struck him with her own vehicle, but hence why she's getting charged with the FA. I went a little bit further in terms of digging too. There are actually two other individuals on top of this complainant that have PPOs against this gal, Judge. So this is an escalation. First, we start with an MDOP, and then it's a higher MDOP. We have all of those convictions. Now, allegedly, the defendant is using her car trying to run over this individual. So respectfully, Judge, we're going to be asking for that cash bond that I previously asked for, as well as monitorization.
Thank you. Two questions before we get to defense counsel. One, I saw in the investigator's report that the complainant said he was going to seek a PPO. Do you have information that there was a PPO in place?
Yeah, Judge, I have a PPO. Actually, the three I ended up pulling off of the CCA, the lean PPO database. And I don't have, I have that there was a serving date of February 7th. I have an additional, oh wait, hold on for a second. No, I want to get all of these names right. For one individual, there was a PPO, and that was February 7th. Then this particular individual, the day of the incident, I believe it was 2/27. That's when he ended up filing it. That's what it has in the CCH.
After, so there would not have been a PPO in place when this occurred. Second question is, you stated she was currently on probation, and I'm asking about whether that probation involves this particular complainant, because I want to know if she was under an order to stay away from him. Does the prior DV, because he said they never dated, they were just friends, so does the prior DV involve him?
You know what? That was over in Macomb. So all I was able to do was go into the Register of Actions over there and look through the entirety of the Register of Actions to see what was going on. I didn't get the name of the complainant involved in that matter. But Judge, at the very least, we have a condition in one of the ongoing cases that said no contact whatsoever with the complainant or the address over a 36.
Okay, which case was that? I'm curious about that. What was the nature of the charge in that case?
That was an MDOP 1,000 to 20,000.
That's one of the malicious destruction. Okay, thank you. That answers my questions. Thank you. Okay, defense. Argument for the defendant, please.
Yes, Your Honor, I was unmuting. I apologize. So, Your Honor, I do know that these parties, obviously, I don't know what's going on between them, but I do know that they're not good for each other because she says the complete opposite. She says he hit her car. And when I look at the report, I don't see any witnesses, anything. I know the officers observed like the damage to the vehicle, but his front bumper is damaged, which would go with what she's saying that he hit her car, but then he says, oh, she backed up on it. So I really don't know, Your Honor, what is going on between these parties. She says he hit her and with the car, tried to run her off the road. He says the opposite. So it sounds like he said, she said here. But I do know that it does not help my client that there is some history with these parties and these cases and these PPOs, against her. But I believe that say no contact for these parties. My client understands that. She doesn't want any contact. She was, this incident was at his home. They are for some reason always together. When he alleges he doesn't want to be with her, she doesn't want to be with him, but then yet they are. She's a lifelong resident. Respectfully asking the court to consider a high personal bond, absolutely no contact, and if the court is not inclined to do that without a tether, then we understand she's looking for a job, so she's not employed, so technically she doesn't have to leave her house for anything if the court is comfortable with a house arrest and personal bond.
Thank you. The fact remains that, regardless of who said what, this defendant was under an order to stay away from this complainant. And we wouldn't be having this discussion if she had done that, if she had complied with a court order. And so her behavior tells me she either is not capable of or does not choose to comply with court orders that tell her to stay away from this defendant. And now I've got multiple PPO causing me concern. And you apparently don't understand that when I'm speaking, you're not supposed to be talking.
I didn't have a PPO out for me to tell me to stay away from her.
That's clear to me that you didn't have a PPO at that time. That's why I asked the prosecutor's office about that specifically. What is clear to me is that you were under an order because of another pending case for malicious destruction of this complainant's property to stay away from him and his property. And despite that order, you were in proximity to him and his property. Whatever else happened, you broke the court's order to stay away from him and his property. And so apparently, the only way to keep this defendant away from this complainant is to keep her incarcerated. And so I'm going to honor the people's request. Keep talking. Go ahead.
I would never go and see this man again. This is done. It feel like after this, when I seriously
Miss
needed this
Payne,
one more
I
thing
have
where
to
I was
interrupt you, Miss Payne. Everything you're saying right now can and will be used against you. It's all part of the record. We said this during the interview. The court tried to tell you as well. Please don't interrupt the court. It's important that you listen to the orders, but I need to tell you to exercise your right to remain silent. We have prosecutors on and it's all part of the record. So anything you say right now is going to be harmful to you.
Yeah, I'm just letting you know I would never go see this man again because I don't want to go see this man again. But I never knew a PPO was out anyway because I went over there. If I knew something was domestic, I wouldn't keep on violating my rights because I don't want to keep going to jail. I have been in jail for 3 years for this man. And y'all think I still want to be here and still want to go back and still get house arrest and still getting charged for this man?
Well, let's see, you've been in jail for 3 years, yet there you were with him 2 days ago. 3 years versus 2 days. So suddenly you've come to your senses. I don't know. Bond is set at $75,000 cash. GPS house arrest before she leaves the jail. If she makes the bond, there is to be no contact. One more court order that you are to have no contact with him or attempted contact with him. We'll see if this one works.
It will.
Next court date is a bond review hearing next Monday. You better be quiet so you can hear when to show up for court. If you're able to get out, March 4th for the bond review on Monday. March 7th for probable cause conference. March 14th for preliminary examination. Both of those in front of Judge Giles. The 4th in front of McConico. You're not to have any contact or attempted contact with the complainant, nor are you to go to his residence or place of abode. And you are not to purchase or possess any firearms or other dangerous weapons during the course of your bond. And if you're able to make bond, there will be no driving. Okay, thank you.
Thank you.
Why do I gotta pay the highest bond and they acting like I can pay it? So I can't get out of here until
By now, I guess it's gonna take a lot more explaining. Please go on.
So I can't get out of here until that bond paid.
Correct.
And somebody explain it. Ms. Martin? What? What?
$75,000 cash. Not sure it's a $75,000 cash bond. Your name, ma'am?
Good evening, my name is Armia Martin.
All right, Ms. Martin, you've got some traffic misdemeanors where you missed your court dates. When you missed your court dates, judge signed to those cases, issued warrants and set bonds. I'm gonna set the warrants aside today and give you personal bonds on the tickets. You do have the right to remain silent. You are being recorded. Anything you say could be used against you in the future. You also have the right to have an attorney represent you on the tickets. If you can't afford one will be provided for you on or before your next court date. These are misdemeanors to which the maximum possible penalty is up to 93 days in jail and or a $500 fine. Ticket P1263296 alleges October 20th of 2021 at Manor in Wadsworth, driving while license suspended. Ticket P1282961 alleges November 24th, 2021 at Linden and Hubble, driving while license suspended. Ticket number P1378301 alleges August 9th of 2022, Chandler Park, driving while license suspended. Ticket P1394056 alleges October 30th of 2022 at I-94 and 75, driving while license suspended and no insurance. Ticket number Z8086521 alleges November 24th of 2021 in the area of Linden and Hubble. This is an OWI. Then we've got ticket number 173530543 alleging May 10th, 2017 in the area of Buena Vista and Petoskey, unregistered or untitled vehicle. Again, personal bonds on all of these. Next court date in front of Judge Wagner, March 28th, 2024 for pretrial. Now calling case number 230-598-2501, People of the State of Michigan versus Ariel Martin, counsel.
Good afternoon, Lisa Coyle appearing on behalf of the people.
Jessica Scheibe on behalf of Ms. Martin, who has formal reading understands her constitutional rights. It says,
thank you, counsel. Court notes formal reading has been waived, enters a not guilty plea on your client's behalf, and I'll hear arguments as to bond.
The people have no objection to a $5,000 personal bond in this matter.
Thank you.
No objections, Your Honor.
Thank you. Bond will be set at $5,000 personal. Next court date is going to be March 8th for probable cause conference, March 15th for preliminary examination. You are not to purchase or possess any illegal substances. Can you hear me, Ms. Martin? I realize there's quite a bit of commotion behind you.
The girl yelling, I really can't, I ain't got my glasses on, I really can't.
All right, thank you. EDC, we're gonna need to do something about the noise level so Ms. Martin can hear her arraignment.
Yes, ma'am.
All right, Ms. Martin, can you hear me any better now?
Yes.
All right, thank you. Your bond is set at $5,000 personal, ma'am. You don't have to pay to get out of jail. Your next court date is going to be a probable cause conference, March 8th. Preliminary examination is set for March 15th. Those are both in front of Judge Sabri. You're not to drive without a valid license during the course of your bond, and also you cannot purchase or possess any illegal substances. That includes prescription drugs for which you do not have a prescription. All right, thank you.
Another question, how would I remember my court dates? I get something in the mail.
They'll give you something there, ma'am. They'll give you some paperwork, okay?
Thank you, thank you.
All right.
60 days. Sorry, Your Honor, what was those court dates?
March 8th and March 15th in front of Judge Sabri.
Okay, thank you.
Thank you.
Thank you. Good afternoon.
Good afternoon. What's your name?
Purdy Jones.
Okay, Ms. Jones, good afternoon. Calling case number 9507134301, People of the State of Michigan versus Purdy Jones. Counsel?
Thanks, Judge Stevenson, for the people.
Jessica Scheibe on behalf of Ms. Jones, who is formal reading understands her constitutional rights and stands mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. This is a case from 1995.
Sure.
All right. Positions as to bond?
Personal.
Okay.
No objections, Your Honor, but can we just know what the maximum penalty is on this? Because they don't have a file. It's so old, and we know things have changed with this, and we want to make sure she has the accurate information.
So this is a malicious destruction of personal property. I'm looking to see what statute it's charged.
If it's
under.
under 100,
I
it's a misdemeanor. Over 100, it is a felony.
Okay. And I also think it's actually changed since then, and in terms of how it was charged prior on how it's charged.
And that's what, why we were asking.
So I'm looking for the complaint. Because it's so old, I don't have that.
I'd just like to make a record right now. I tried to keep this as short and simple as possible, and it wasn't me who asked you that question, Judge, and elongated this.
Oh, no, it's okay. Well, this is the last case of the day, and I like research, so let's just take a moment. Seven 503. 1 moment. Let's see. I've got two different statute numbers here, which is a little bit confusing. So just give me one moment. One of them may be a typo. Let's see. Yeah, that's not right. 37A.
There's a possibility it may not even exist based on the research that I ended up doing. So, I mean, it would get converted to something, but at least the way it was captioned.
Yeah, so I'm looking at a 2023, because I don't see the statute. I'm linking to a 2023 unreported case, Singleton. I'll try to go from there. And I think you're right, because there's no link to the statute. However, this case, this is an appeal, so it involves a prior conviction under that statute.
Maybe one of Ms. Scheib's plethora of law clerks can get into it too.
Yep, that's gonna be one of theirs that's gonna have to go through. I tried just doing it without the subsection A. That just takes me to a whole different use of indecent and vulgar language. That's not what we're dealing with. So.
What do they say about good intentions? They're the pathway to something.
We'll be here all night. 337.
May I interrupt?
Yeah.
I'm
Sure.
looking at the ROA, and I know MDP over 100. Unfortunately, I'm old enough to practice before the law changed.
Okay.
And yes, just like RCSP used to be over 100 was a felony, this as well is a felony. And if you look at the top of the ROA where it says case number, it's 950713431. And if you see FY, it says felony. So I'm very certain this is a felony.
It's
Okay.
just, it's been converted, but okay, we'll just leave it at that.
Well, so
So,
the issue for me is, as a matter of arraignment, I need to be able to tell her a felony for which the maximum possible penalty is XYZ. And that's what I'm having difficulty finding.
I believe I'm going to check, but this is off the top of my head. It's either a 4-year or 5-year felony. My guess, I'm going to say it's a 4-year, but I'm going to look for you right now.
Thank you.
This is so ironic when I just come on the screen and say personal, and it's like our longest case of the day.
Yeah, but this is part of arraignment. Part of arraignment is that
Oh,
the defendant
absolutely.
has to be advised of the maximum possible penalty. That's what's catching us up. All right, Ms. Jones, this is an exercise that we're going through so we can advise you of what the maximum possible penalty could be. Ironic, as the people say, because you are probably nowhere near getting anything close to the maximum possible penalty in this case. And you're getting a personal bond today, according to the people. That's what they're requesting. So you're not going to have to pay to get out of jail. We're just trying to advise you of what your maximum possible penalty might be as the case goes forward, even though it likely would not apply to you.
Okay.
Malicious destruction of personal property. Let's just try this.
Your Honor, may I ask if it's being set in front of a judge for felony, like what court dates and stuff, so we know how
It's being set, it's set in front of Judge Sabri, so all that,
Okay.
now we're down the line that it is a felony. I would agree
Okay.
that it's charged as a felony, but I'm just trying to understand the maximum possible penalty.
Thank you.
Mhm. Okay, here we go. 377A. Nothing in this case, not even an investigator's report.
Nothing, Judge. Zero.
When was
In
the
fact,
complaint
in
signed?
fact, I looked up the defendant to the criminal. All we have are a pair of 2019 traffic citations. Now, why at that time she wasn't arrested on this was because it wasn't even in the ROA at that time. So,
Okay, so it was signed in 1995.
yep.
Original charge, malicious destruction of personal property over $100. So we're not, I mean, the way that our statutes are, the statute is written now, the problem is it's, you know, we've got $200 or more, but less than 1,000. All of those are over $100. If the amount of destruction is less than $200, so this doesn't make any sense. So the issue is there's a section that speaks to misdemeanors if less than $200, and this is charged as more than $100, but then it goes all the way up. There are so many tiers over $100 that change the maximum possible penalty. And without an investigator's report such that I can even discern what the amount of property destruction is alleged, I have no way of knowing what the maximum possible penalty is.
The crime, and I'm looking at case law, that the statute only requires exceeding $100 to be a felony, and that's all that needs to be shown. It doesn't demarcate, and I recall from practicing, it does not require steps like it does now, where it's broken it down to a 93 1 year.
And do you, because I can't link to the old statute through, I don't have a way of linking to the old statute, which is what I was trying to do. I'm looking at the history.
To find
So
a
what I'm
different,
trying to determine is what the maximum possible penalty was, even in 1995 as charged.
right.
I believe it was a 4 year. I'm looking at case law. That's what I'm looking at right now, because
I couldn't even find the different tiers in the statute, Judge, because this was over 100, and then I was looking just like you said, because now we have the 2 to 1,000, 1,000 to 20, and all of that. So I couldn't even find that.
but that doesn't exist before.
Right, when I look at the graphical statute, it only takes me back possibly to 2007.
Right.
Lord.
Yes, like I said, I practiced during that period, and I'm also looking at a 1997 case right now, People versus Hamlin, which is a Court of Appeals case, which does talk about that, Your Honor. So it is either a 4 or 5 year. I believe it's a 4 year felony. I know it's a felony for sure, over 100, and it was under 100, over 100 at that time. I'm positive.
All right, and I don't have a complaint, so I don't know whether there's any habitualizing happening in order to increase the maximum possible penalty. So Ms. Jones, this is a matter that you will continue to raise through your defense counsel, I'm sure. But at this time, it is a maximum where it appears that the maximum possible penalty for the charge you are facing could be up to 5 years imprisonment, you know, as a maximum. It also could be 4 years. We're trying to figure it out. And, you know, honestly, there's probably an issue for appeal right here because I can't, you know, despite my best efforts, figure out how to advise you of the maximum possible penalty of this offense, which you are supposed to be advised of as at arraignment. I'm doing my best and trying to err on the side of caution and tell you that it looks like it's going to be up to 5 years imprisonment, but it also could be 4. It sounds like according to folks with experience in the area at the time. Okay, defense counsel, it looks like Klein had her hand raised.
Yes, and before that, just for the record, she turned herself in. I know no one's not worried about any of this. It's such an old case, most likely probably gonna just get dismissed, thrown out. It's not even written right. There's no file. But Ms. Jones, did you have a question? I know it's a little confusing what's going on right now, and we explained it to you. We were just trying to get the maximum penalty, but anything you say right now kind of will be used against you. I'm not really worried about that here, but I do have to advise you of that. The court knows you turned yourself in. So do you have a question?
No, I can wait.
Okay, thank you, Ms. Jones.
Also interesting that this was originally set in front of Judge Jones. And then it was changed to Judge Sabri. So adding another wrinkle as to whether we are dealing with this as a misdemeanor or a felony. You know, this is something that needs to be raised in front of the judge in terms of figuring this out and where it should be, because the fact that it was originally placed in Judge Jones would cause me to believe that it was being charged possibly as a misdemeanor and not a felony, for which the maximum possible penalty would be up to 93 days in jail and/or a $500 fine. So now we're all over the place. We're all over the place with this. I don't, however, have anything before me stating this would be a grounds to dismiss the case at this time, but it may be grounds later that you can't even properly be arraigned on it because we can't figure out how it's charged. We don't have an investigator's report. We don't have anything to help us out here because of the age of the case. At any rate, at this time, I'm going to set a personal bond. I'm going to set a personal bond in the amount of $500 because it's not clear to me that this is going to go anywhere at all, really. Not a flight risk since she turned herself in, not a danger to the community given something that's from 1995. I don't even have an investigator's report so that I know what those allegations were in 1995.
All right, but Judge, here's the $64,000 question. Are we getting a pretrial date or are we getting a PCC? And
well, at this point, it's been transferred to Sabri, so you're going to get a PCC as well as a prelim date because it's with Judge Sabri. But that's, you know, it needs to be raised with Judge Sabri and probably brought to Judge Sabri's attention that this was really just recently in 2023 set before Judge Jones and then transferred to Sabri. So somebody's going to have to, somebody who has a lot more time to figure this out is going to need to figure it out.
Yeah. Okay.
All right. All right. Next court dates are going to be March 8th for probable cause conference, March 15th for preliminary examination. And they're both set in front of Judge Sabri. Your bond is $500 personal. You don't have to pay any money, get out of jail. Just show up to the court date, talk to the defense attorney, and, you know, hopefully they'll help you raise these issues, start this mess. Honestly, it may be grounds for dismissal that we can't even figure that part out. All right, thank you. All right, bye-bye.
Okay, why y'all just looking around and I get my stuff so I can get out of here?
I don't blame her. All this time later. Okay. All right.
That was it?
I finally see you, and you can be complicated, Mr. Vincent.
Yeah. You know what? It's always fun, though, Judge. I appreciate it.
All right. See you later.
All right. See ya.